But without further ado, I'd like to introduce our presenter, Mr. Lee Caffin. Lee is very experienced in intellectual property. He is a very experienced intellectual property professional, having held head of department positions at leading multinational companies in both Europe and the U.S. His work spans all aspects of intellectual property procurement and strategy across multiple technology disciplines, including IP portfolio optimization, defense, monetization, licensing, regulatory interface, and litigation strategy. Lee also has a special interest and expertise in developing company structures and department interplay to ensure effective harvesting and use of company inventions, and to mitigate business risks. At this time, it's my pleasure to hand it over to our presenter today, again, Lee Caffin. Lee, good morning to you and welcome. The floor is yours. Thank you for being here.
Thank you, Brooke. Welcome, everyone. Good day. I'm going to break this presentation down into three areas. Brooke has indicated how that's going to play out. Initially, I'm going to give a fairly high-level overview of the NPE market and then take a deeper dive into some US and overseas NPE activity. I'm next going to look at some of the risks posed by patent assertion entities and trolls and try to convince you that the risks are not completely aligned between PAs and trolls. They're not necessarily covering the same types of activity, and the threats are not identical, at least to my mind. And then I'm going to look at some of the litigation venues and some of the activity in the courts and other forums. So moving along, I think it's worth initially looking at definitions. There are certain groups that would call trolls, patent assertion entities, and NPEs one and the same thing, but to my mind they are a little different. NPEs, I'll use the patent freedom definition, and I'm happy to use that. It's any entity that earns or plans to earn the majority of its revenue from the licensing or enforcement of its patents. And included within that overall definition are universities and other groups which we wouldn't really look at as patent assertion groups. Their business model is to develop or to discover, innovate, potentially to develop products through to a certain stage, but their remit really isn't generally to go forward and sell those products in the marketplace, but look to license out their technology to companies who are more able to do that and have the finances to do that. So not all NPEs are bad, and even patent assertion entities, which are a subset of NPEs, whose sole goal is to license technology and license patents or purchase those technologies and patents and then look to develop a licensing model. But trolls I regard as a separate group. If we're looking for bad actors, then I would regard trolls as those bad actors. They are clearly trying to utilize and play the system to their benefit financially. They clearly understand that litigation, particularly in the US, but also overseas, is very, very expensive. And if they can extort a relatively small licensing fee from a number of different companies, usually on patents which have very vague patent claim language, are often, when challenged, found to be invalid. But the goal is not really to litigate to the very end, but to obtain licensing revenue, and will attack a number of smaller companies and individuals even, and try to gain licensing revenue rather than those individuals having to go through the expensive litigation process. So I look at those groups as overlapping to a certain extent. NPEs can undertake troll activity and PA activity, and patent assertion entities certainly will, if it suits them, undertake troll activity, but I don't regard them as one and the same. This slide, which I hope you can see, is just a picture of the public IP sector by market cap. And I show this slide to demonstrate. You'll notice there are some familiar players in the healthcare PAE world. Acacia, I mentioned here, Marathon, a few other groups as well who we'll talk about in a little more detail later, and some of their activities. But this slide is to demonstrate that some of these companies are really quite significant. They're rather large, and they have the financial resources not only to buy up individual some patent families, but can buy up portfolios and are buying up portfolios in the medtech world, as I'll demonstrate later. If we look at some of the portfolios that are held, or at least the numbers of portfolios that are held by NPEs, again, we'll see that they are fairly significant. The families are on the right-hand side, and you'll see that the U.S. patent publications are in the left-hand column. Again, Acacia is fairly high up in that list. At the very top, clearly, Intellectual Ventures is by far the largest. And although we haven't to date seen a huge amount of activity by Intellectual Ventures in the healthcare area of litigation, we do know that they hold a significant number of patents in the medical device area. The estimate is that they have over 1,000, covering at least 100 different categories of medical device. So they are stocking up in this particular area with patent portfolios, and if it suits them, and it certainly will because of their business model, they will assert those patents against certain individual companies and perhaps license to others. This slide was from Patent Freedom. It only covers activity to through 2013. But I think it clearly demonstrates there's been an explosion in NPE lawsuit activity over the last 4 or 5 years. That trend, I think, will continue, not with that exponential growth. We may in fact see that number coming down when the 2014 data comes in by a little, but not significantly. The reason why I believe that number may come down in 2014 is we do have data in looking at patent litigation in the US across the last 4 or 5 years from Unified Patents. It's their data, and there has been a slight drop-off, clearly still more than double the amount of litigation that we saw in 2010. And the thought is that the Alice Supreme Court decision has had an effect on patent assertion in the last year. The AIA may also have had a certain effect on reducing those numbers, although the general thought is that Alice is having a major effect there. This data is a little old, but I think it's quite interesting. I don't expect these figures to change significantly in 2014. But yes, as indicated here, sales to patent assertion entities and other MPEs represented 75% of all patent transactions in 2011, and that's the University of Chicago Law Review paper that quotes that. That's, to my mind, really quite an astounding number. They broke that data down. 40% of those patent transactions came from small companies, another 40% from large companies, and the rest were from research institutions and the like. The other piece of data here is that PAEs in 2012 accounted for 62% of all patent suits, and again that number I don't believe has changed significantly in the last couple of years. Looking across the line at the top, we'll see in 2014 as an estimate, we'll see that the lawsuits, as indicated previously, have grown significantly from 2005 through to 2014, with a slight drop-off in the last year, or an expected drop-off in the last year. If we look at the split, clearly MPEs are very, and have been very active for a number of years in the high-tech area, but they are becoming somewhat more active in other areas, and we'll see in a couple of slides some of their activity in the medtech space. This particular slide shows data prepared by Unified Patents again. They looked at 2014 litigation by sector and compared litigation by MPEs and litigation from operating companies. And again, not unsurprisingly, within the tech sector, MPEs are incredibly active. In the medical area, they are starting to become more active, but it is not a big number currently. But I think we'll see it growing, and I'll try to demonstrate that in this presentation. The medtech, or the medical data, was broken down further by Unified Patents. If you look at just the red quadrant, this shows MPE U.S. litigation against non-SMEs or against larger operating companies, and it's really quite a small percentage of the overall medical 2014 U.S. litigation. It's about 10%, if that. So I guess you might ask, well, why should we really care about patent assertion within the medtech space? The data doesn't really suggest that there's a big issue currently. There's some what might be regarded as nuisance activity, sporadic nuisance activity, or clearly very, very important for those who are involved in that litigation. But it's not consistent. It's not a huge aspect of the overall litigation landscape. But I think that's starting to change. And there are a variety of different reasons why I believe that we're going to see more and more PA activity in the health tech space. Here are a few reasons why I think that's going to happen. I'll demonstrate in the next couple of slides that we are starting to see a rapidly changing healthcare environment in the US and elsewhere, with new technologies and new players taking part in healthcare, and we're going to see that develop over the next few years. When the dynamics in the market change, there are always opportunities, both for innovators but also for patent assertion entities. And if PAs see a chance to move into a particular market, then they will end up obtaining a return on their investment in that market, then they will move into that market. I think the other thing to consider is that the patent assertion entity market itself is changing. And it's changing for a variety of reasons that we'll look at in a few slides. The courts, in particular potential legislation, also public opinion. There are a variety of reasons why the PAE market is changing. I think we're starting to see some consolidation there and some diversification. Also, and again, we'll look at this in a little more detail in the coming slides, there's a greater emphasis within companies on trying to really gain a return on investment on IP assets that they've either developed themselves or licensed in initially. So there are monetization programs within most, if not all, large companies now. And PAEs, again, are aware that there are opportunities to purchase patent portfolios in this particular space and gain revenue from those patent portfolios. I think the last point also is that the revenue models for licensing and trading intellectual property has been on the decline. There was a huge peak a few years ago with Nortel and Google, mobile phone area in particular, where some of the numbers were being run up significantly. But of late, that trend has gone into reverse somewhat, and so there's a little more realism, I think, now around the value of certain IP assets, and I think in certain areas that need to build portfolios as defensive activity. And the competition in those areas for those portfolios really elevated the prices. But generally, we're not seeing that kind of activity of late. And so with more IP monetization, with the price being at more reasonable levels, again, PAEs are going to look very carefully at the opportunities and move in where it makes sense for them to do so. So I'm going to look now at in a little more detail at a couple of those market reasons why PAEs and trolls, I think, are going to become more prevalent in the medtech space. The first is the healthcare market generally, and I think this is where trolls will have a greater influence than previously going forward. Also PAEs. The second is the review of company activity and monetization within companies. And I think there, in the medtech space, we're going to see less troll activity, and it's really a PAE play. Larger PAEs who can afford to buy up significant portfolios and assert them. So we are seeing, and we'll continue to see going forward, an evolution in the healthcare market, with technology being really at the center of a lot of the shifts and the movement in the marketplace. The healthcare sector itself, from a number of different studies, is going to shift towards more customer empowerment. We are seeing already that Congress, government, and the FDA are likely to take more of a hands-off approach to health IT than other areas of healthcare. They want to enable, where possible, the use of technology in this market and not be seen as a block. So I think we're going to see that have a significant effect on how quickly the market develops. Again, studies have shown that consumers are really looking in their healthcare for transparency. They're looking for transparency in terms of the coverage that they're obtaining, the cost, transparency in diagnosis, gathering of information, using information. They're also looking for convenience in terms of where they get their healthcare. And a big market going forward will be the preventative measures, with your healthy lifestyle being a significant factor in the overall market, and encouragement to develop a healthy lifestyle and utilize the health IT tools that are available and will continue to be available to help to sustain that. From data that has been generated through surveys, here are some examples of what we expect to see in the not too distant future. We're going to see more home diagnosis and use of diagnostic kits within the home setting. Certain treatments are going to be administered in the home. Customers and consumers will have more information available at their fingertips to compare healthcare costs and look at the quality of the healthcare that's being provided in a much more all-encompassing and detailed way than has previously been available. And we're already starting to see, and we'll continue to see, more apps for monitoring and also for sharing vitals, indications of health, and having all of that linked through either to hospitals or physicians. Much more of a progressive healthcare system than has been to date. I think when we look at where things stood a number of years ago, it would be quite difficult to have predicted that today it's quite routine for anyone to get flu shots in the US in their neighborhood stores. And we're moving from that to pilots which are being undertaken within Walmart and other stores, where they are now starting to look at introducing micro clinics. So again, moving healthcare provision out of the hospitals, out of the doctor's area, within hospitals and within practices, and into more local neighborhood areas, more convenience for the consumer, and with that, one expects the cost also to be reduced. So if we look at this particular slide and the data that's included here, this is from a PwC Health Research Institute report from late last year, and it's pretty simple pictorial. What it demonstrates, what they demonstrated, was that within the top 50 companies in the US, the anticipation and expectation is that almost half of those companies will start to enter into the healthcare area. And if you look at the categories of those companies, they're not necessarily the types of companies you would expect to see, or not all of them are, but it just demonstrates that it's an area that is going to explode, and we are going to see a number of new players and with new areas potentially of healthcare that are going to be developed, and also clearly the use of technology within existing healthcare fields and the growing use of technology within those areas. We're also seeing venture capital being made available in startups in a number of different healthcare areas: digital health, price transparency, electronic medical records. From my own experience, I'm based in Chicago, and mentor some of the local groups that spin out from the Chicago universities. And we see that a significant number of those new fledgling companies that are just starting to come out of those institutions are in these areas, and they are gaining the sort of funding that they need to develop their businesses further and to grow into real companies that that can generate revenue. So we are seeing, whereas in other areas perhaps venture capital is still very difficult, and some areas of the life sciences disciplines for small startup companies, venture capital is really quite difficult to obtain. In these particular areas, money is much more readily available. I showed this particular slide really just to pose a question for you. The slide demonstrates patents that have issued in the US in 2014, and these are the top 10 or so patent holders, IBM clearly being right at the forefront there. And the blue, as indicated, shows the total number of patents that are issued, and the orange-red bar shows the number of patents that are issued in software area or business method area. And I guess the question that I'd posed here is, if you're looking at health IT and you're a company that has a business goal and business strategy around utilizing and obtaining market share in the health IT area, then questions: how could any of these patents that have been granted in the business method and software related areas, how could they influence the marketplace? Are there any key underlying technologies here which are going to in some way present either a barrier or potentially an opportunity for you to partner with one or more of these groups to give you an advantage in that particular market? So clearly there are the majority of these patents will not relate to health IT, but if I were working within a company that was looking to develop a more major presence in health IT, then I would start to investigate some of the patents that are covered here and look to see if any of them are going to have any impact on your business strategies going forward. So coming back to NPEs generally, so what are the knock-on IP effects that this activity in the medtech health IT area going to have? Well, there may be some precedents from other industries to look at, banking, retail, entertainment, for example, where they've seen some really significant changes in their business practices through the introduction of technology. And so what they have seen, and you'd anticipate it entirely likely that this will be the case in medtech as well, we'll see more complex patent landscapes with more FTO landmines to address. Clearly more players are involved, more variety of patents that they need to look at for clearance exercises, and they've seen patent assertion entities, and they've also seen significant control activity in their areas. In the medtech area, as I try to demonstrate, clearly I believe we're going to see more PA activity. Classic troll activity, the troll activity that I mentioned up front, trying to extort money using individual patents with dubious validity and vague claims. Probably going to see less of that sort of activity in the health IT area, although we will see some, certainly. So what are the creative defense strategies that the banking and other industries have been using? Well, clearly litigation, defending their position in litigation if sued. There are also patent pools and defensive aggregators. And defensive aggregators really are front and center in trying to address upfront PA-focused activity. And I'll just touch on some of those defensive aggregators and what they do in a few minutes. You can build or buy portfolios to stay in the game, and we're seeing that in other areas. And then clearly there are opportunities to partner with some of these new entrants, and I think we're going to certainly see that. We saw that in the banking industry, Google Wallet, Apple Pay, other types of technologies, and those companies have been partnering with the banks to introduce their products. And so in the health IT area, we're going to see that as well with Google and Apple, who don't really have expertise in this market. They will buy into this market by partnering with appropriate healthcare providers. They also don't have the reputation in the area which established companies will have. So moving on to the second market aspect that I wanted to touch on, and that's really IP within companies and in the boardroom in particular. And we're starting to see within most, if not all, companies a real emphasis on utilizing IP to leverage business activity. The reasons, there's been a huge amount of media coverage around IP in the last few years. The Apple, Google, Samsung, Motorola battles have been, if not front page, page 2 news. Clearly in some areas of the life sciences there has been the well-reported patent cliff with a number of established and very lucrative products going off patent. And I think we're also starting to see some effects of the IP effects on potentially IP effects on balance sheets as well. We're not going to see IP, I don't think, for a few years at least, be quantified on annual returns, company returns, but certainly internally IP is being valued within companies. And there's also within companies that have significant software IP property, companies are looking at what kind of effect the Alice decision, the Supreme Court decision, has had on the value of those types of portfolios. The other bullet here is the recent activity by certain hedge fund managers who, and it's been well reported that they, along with patent assertion entities and one in particular IP NAV, are looking to file IPRs on what they regard as life science patents which are valueless. They regard as valueless and invalid. At the same time, driving down the price, the share price of those companies. So they are targeting companies like Accorda, who perhaps have 1 or 2 products covered by patents, and clearly if those patents are in doubt, or at least even challenged, then the share price of those companies is going to go down significantly. They say that they're opposing these patents for reasons of bringing down the cost of healthcare for consumers, but they're also at the same time generating revenue for themselves by depressing the share price and gaining revenue when the share price rebounds a little bit. So some of the directives, I won't go through them in detail in the interest of time. I just point out the last bullet, which is the monetization of non-core assets, and we're seeing more and more of that within companies. We're not only seeing the more traditional way of monetizing, using your BD departments or agencies to shop the assets, or potentially to spin out the assets into a separate company, but also products and more particularly patent portfolios, not products, are being sold to patent assertion entities. So why are PAs interested in medtech? Well, their model is evolving, as I mentioned. There's more consolidation. Although high tech is still a core, PAs are diversifying into other areas, including medtech. There's a natural maturation process as the PAs are evolving and their market's evolving. But there, to a certain extent, I believe there's an Alice effect, and they're looking to get into patents which are of higher quality, potentially, and less susceptible to the Alice decision and invalidation under those premises. They're also opportunistic, as we said before. Companies are looking to monetize. Their targets are cash rich. The market is changing with new entrants. There's lower valuation. The revenue sharing models, so we're starting to see some of that's interesting. There may be some FTC interest in some of those types of models going forward. They're looking at, the FTC is looking at patent assertion entities generally, so it'll be interesting to see what scrutiny they place on some of those types of revenue sharing models as going forward. So what are we seeing? What are they buying? Well, we're not yet seeing, say, significant activity in the health IT area. We're seeing a little. The market's immature. There's some caution, I think, getting into the high-tech area after Alice. Do they want to take on Google and Apple getting into the health IT market? Maybe. I don't necessarily see that as a barrier. But I think more importantly, they're starting to go after what I call the low-hanging fruit at the moment. MedTech or medical device portfolios have come up for sale. They're available. There's a perception of strength, which is important. The medical device area litigation there is well established, and we've seen historically some high damages awards, so that's another incentive for PAs to get into that area. And so also the target companies, the high worth target companies, they have the financial resources, and as I say, damages awards can be quite high. So they are actively acquiring and also litigating at the moment medical device portfolios. And we'll see that in just a couple of slides. We are looking, I think, here at a slightly different model from the high-tech PAE model. We're unlikely in this area to see significant control activity. The PAEs are buying up larger portfolios in the medtech and medical device space. They're looking to litigate potentially through to conclusion, rather than purely use litigation as a tool to pressure licensing under the traditional trial model. But to do that, it's expensive, and so the PAEs who we're seeing enter this field are some of the larger ones that I've referred to before, at Casey and Marathon and a few others, and I expect that that model to continue going forward. So who's buying? I think in the interest of time, I'm going to skip through those. You'll have the slides so you can see what the situation is here. I just point out that what we tend to see is large portfolios being bought. then almost immediately the PAEs suing a number of medical device companies in district courts under a variety of the patents, not just single patents, but a number of the patents. And then in response, we're seeing some of the companies filing IPRs to try to have those patents invalidated. So I'm going to change course a little bit here and get on to the next piece of the presentation, and I'm going to have to go through this very quickly in view of the interest of time. But looking at the various battlefields, the battlefields in the federal courts and the patent offices, and I'll just touch on ITC and also the FTC. If you look at the comparison of costs between federal court, ITC, and IPR, you'll see the cost between the ITC and the federal court around about the same number, although the federal court costs are spread out over a longer period of time, so you get a decision faster in the ITC. That's similarly the case with IPRs, faster decision, and also if litigating or if undertaking one IPR review, the costs are significantly less. So patent assertion in the federal courts, there's been some good news by the Supreme Court in addition to Alice, which I think means lower leverage for patent assertion entities. A number of years ago, 2005, the eBay decision came out, which made permanent injunctions less likely than before. The Obtain, Fitness, and Highmark cases you're probably familiar with, which is I refer to as a nod to loser pays. So it's somewhat easy now to be awarded attorney fees if you win a case. And then there's the Nautilus case where the CAFC held that the bar was too low in allowing patents with claims that were written very vaguely. And so that's a direct attack, I think, on troll activity, or certainly has direct influence on troll activity. The bad news is the Taylor versus Sando decision, to my mind, with claim construction deference being given to the district court, not subject to de novo review by the CAFC. That will, in all likelihood, increase cost and uncertainty. Claim construction will be delayed. Broad-based claims will be discussed, debated, and construed over a longer period of time, with much more emphasis going into that part of the court process. And we may see some variation between different district courts, so there could be opportunities for some farm shopping by PAs to get the sort of decisions that they're looking for. Perhaps not, it's more case by case, but we may start to see some trends in district courts. If we look at a couple of other issues in court proceedings, we will, one way or another, see some federal court rule changes to heighten pleadings. Trolls in particular have generally filed infringement claims which are really quite bare bones, vague claims. Those types of claims are going to be subject to scrutiny and are likely to be subject to will be subject to motion to dismiss activity, and I think those motions will be granted. So it's going to be more difficult for trolls and PAEs to assert very broadly, which again means that it's going to be difficult to generally join cases together. There's going to be much more particular pleadings necessary, and that'll make it more expensive for PAEs. I'm going to skip over the venue issue. Clearly after the AA, it's become much more difficult for PAs to join different companies in one infringement suit in one court. There may be some strategies around the multi-district litigation process and consolidation pre-trial to mitigate some of those joint limitations. And there may be anchor strategies also to keep cases in courts that are preferred by PAEs going forward. If we look at assertion via the US ITC, it is a powerful exclusion tool, but I think there are limited opportunities for PAEs here, particularly after a fairly recent case involving optical devices who were a licensing entity. They, as I indicate, they purchased or licensed patents from a number of companies, including Sony and Sharp, and in order to exclude products coming into the US market from overseas, which infringed, or they regarded was an infringement of their patent rights, they went through the ITC process and attempted to show that they had a domestic industry in these particular patents because of the agreements that they had with both Sony and Sharp. They, however, did not invest in the technology itself, and so when the ITC looked at the business plans, they held that it lacked any discussion of activities directed towards creation or development of products based on the patented technology. And so the decision there was that they couldn't establish it as a domestic industry as a matter of law, and so they weren't able to utilize the ITC process for excluding products coming into the US market. In the overseas, court assertion by PAEs in Europe generally, there's, I think it's generally true to say that there is a loser pay process for trial costs. At least some of the costs are repaid if you win. That's an issue for pure trolls, and so there's less incentive for trolls to, or has been for trolls to go through the European litigation route generally. It's less of a disincentive for well-financed PAEs. Also multi-jurisdictional litigation is expensive, so pure trolls where they have gone into the European market and sought to enforce patents, they've been very selective on their venue, and they've often gone to Germany. The Unified Patent Court, I just mentioned that we're unlikely to see activity through most of 2015, but it may come into effect towards the end of 2015. That's likely to be fairly attractive to PAs for the reasons mentioned. Decisions are effective across Europe, so there's a significant impact economically on the loser. Bifurcation, separation of validity and infringement proceedings is likely. It's based, the Unified Patent Court is based principally on the German model, where bifurcation is in effect. Injunctions are also possible. They're more likely in Europe certainly than in the US following eBay. And we can, with bifurcation, see injunctions before validity is determined in a separate court. So that's a really strong lever for PAEs and trolls to use. And also with the Unified Patent Court, as we saw with the European patent process 25, 30 years ago, initially it's difficult to predict how cases will be decided until a body of case law is developed. So with uncertainty comes opportunity for PAEs and particularly trolls who, as I mentioned before, are not looking to litigate through to the end, but to raise concerns and uncertainty in the minds of the people who are selling products, and so maybe more likely to settle. In Germany, as I mentioned, it's a relatively inexpensive and fast court process. Bifurcation exists, injunctions are possible, therefore, and have been granted before validity is determined, and it's a pure loser pays legal cost system. I think the losers pay 100% of the costs, or very close to 100% of the costs. We have seen a couple of examples of PAEs asserting patents in fairly high-profile cases. Just recently, Marathon sued Apple in the Regional Court of Munich for the iCloud system. That's very early stages. The second example is one that's run its course, and IPCon sued Deutsche Telekom, and in 2013, 20 patent cases were settled, and commentary has been that IPCon netted multiple hundreds of millions of euros as part of that settlement. And IPCON is based in Germany, is very active in litigating patents in Germany. In the UK, it's moderately fast, or it's very fast, moderately expensive. There is an issue, there has been an issue historically over staying of the UK proceedings pending EPO decisions on validity of patents. There's one example in the next slide, I believe, that plays that out and shows how that can have an effect. That's changing. The UK is now more likely than not to grant a stay of the UK proceeding until the EP decision runs its course through both the opposition and appeal proceedings. Loser pays most legal costs in the UK. There's a certain formula I think that applies in the UK, but true to say that loser will pay most of legal costs, certainly will pay on those parts of the ultimate decision that they lose on. And one example here, a recent decision is Ringo suing a Chinese company, ZTE, for patent infringement. And they won. And the patent itself was a standard essential patent, SEP, in the telecoms industry. It demonstrates the potential use of the UK system and the ability of pure trolls in this case to generate significant revenue and gain positive decisions from the UK courts, as they have done in Germany also. So some of the defense strategies, and I think we're approaching the end of our allotted time, but I'll quickly run through these. There are obviously traditional defense strategies, early and continuous FTO, workarounds, clearly filing patents, defensive publications potentially, purchasing patents ahead of PAEs is clearly going to need good network, good search analytics, good scouting. Question clearly is, will competitors deal? Will they license? And if you identify patents which may be up for potential purchase, why would a competitor deal with you and not a PAE unless you can provide them with significant financial benefit, and even then they may not deal. Unlike in the company versus company arena, there really are no bargain and chip plays when faced with a PAE. You could work with a defensive aggregator, a licensing pool, and then clearly there are litigation strategies, and we've seen that in the federal courts, the US Patent Office and the post-grant opportunities there, and in Europe through the national courts, the UPC perhaps next year, if not towards the end of this year, and through the European Patent Office. I'm going to just go through this next two slides without talking about them in any detail. I've just listed here four. Yes?
Lee, I'm so sorry to interrupt. I just wanted to let you and all the attendees know, let's just get through the rest of the information that's on there. I can always collect the questions, and Lee and I can do a separate recording. He has been kind enough to provide us with the slides, but if it's okay with you, Lee, let's just finish off strong and go through all of this information just to let the attendees know if anyone has to jump off in the next few minutes. I will be in touch with a survey as well as the presentation recording and the slide deck, which Lee's been kind enough to provide us with. But let's continue through with the information, and if we get questions, we can address those at a later time. Just want to make sure everybody is getting all of their questions answered. Is that okay with you, Lee?
Yes, that's fine. Thanks, Brooke. And,
no problem at all. Please proceed.
I will then start to. I'll go at a slightly slower pace, so I'll get through all of the slides, and as Brooke says, we can address questions later.
Yes, and if anyone has to jump off the line, please, contact me with those questions, and I'll make sure that I either connect you with Lee directly, or we will do a separate recording to provide the whole to provide all the attendees with the answers to those. So, Lee, please proceed.
Thank you. So, aggregation is the safety in numbers. as I was just mentioning, here are 4 examples of different groups who aggregate patents. They have slightly different models. They are very focused at the moment on high tech, but clearly these groups will go where the markets dictate. So if there is a demonstrated need to aggregate patents as a defense against PAEs in the medtech space, then one or more of these companies will likely get into those areas. And from speaking with Unified Patents, not United, and I did notice that typo before and I didn't change it, unfortunately. But the Unified Patents, they the company groups technologies into what they call micropools or zones, and companies can join a zone focused on protecting, as I said, technical area from patent assertion entities and trolls. From speaking with them, they do see that the medical area is one where they will, in the not too distant future, introduce a new zone to cover perhaps medical device. They didn't get into those kind of specifics, but we expect to see them develop another zone certainly in the healthcare area, more particularly the medical area going forward. So, as I say, these companies pull patents. They have different models focused on high tech at the moment, but likely to move into the medical area if the market dictates that they need to be there. This slide just compares 3 of those 4 and how they interact and sell their services to different companies and the types of models that they have. Moving on to other defensive strategies, if we look at litigation, clearly in the federal courts, and we see routinely companies will, if sued, counterclaim for invalidity. It's possible to try to get in first if you've received a threatening letter, perhaps. Try to get the court to issue summary judgment against the patent holder. Just bear in mind, though, that if you go down that path, you will be barred from later filing an IPR under the AIA Reform Act, and so that's something to bear in mind. Also, clearly, you need appropriate standing, and there will be issues around standing for you to precipitate any kind of litigation as essentially a defendant. We look at some of the USPTO post-grant proceedings. The cover business method review is unlikely to be a forum which is going to be relevant to the medical device and medtech area generally. The qualification is that the patent for review needs to be a business method patent, and we have some guidance here from the courts. A Jazz patent, and Jazz is a company that develops small molecule products, and they had a particular business method patent for, I think, distribution of their products in the marketplace. But that was held not to be a financial product, and so CBNs are, at least based on that particular decision, are going to be limited in application to patents which relate specifically to financial products, bank products, etc. Those are available to September 15th, 2020 under the AIA. Will disappear after that period of time. IPRs, there's no standing issue in IPR, which is can be good and can be bad, I guess. It's good if you're looking to defend against yourself against the PAE, but we have seen with the Accorda case, hedge funds getting into this area and filing IPRs, and that clearly wasn't, that's an unintended consequence of the IPR process. So, but as far as defending against PA is concerned, there's no standing issue. 102, novelty, and 103, obviousness. Those are the only aspects of patentability which you can raise against patents, and you can only base those on patents and printed publications. Because of the, the limited validity or invalidity grounds you can raise, there's a more limited estoppel than there is in the post-grant review process, which covers other invalidity grounds. I'll just mention the COSO speed technology case, which you're probably aware of here. This was really a vindication to a certain extent from the courts to, from the Federal Circuit to the application of the IPR and the IPR process. They ruled that the court has no jurisdiction to review decisions by the PTAB as to whether or not to institute an IPR, and they also approved the board's use of the broadest reasonable interpretation standard for claim construction. That's a big issue that's being addressed now in Congress, and we're likely to see a new patent reform law come into effect maybe this year, which has as one of its elements a potential change of the broadest reasonable interpretation standard to clear and convincing, to align it with the federal court standard. But at least for the moment, the broadest reasonable interpretation standard exists within the IPR review process. PRGs, they've only just fairly recently become available, and we've seen very little activity to date, just because there are a few patents that have granted under the and qualify for the PRG process. We look at IPR filing considerations. IPRs may look very cost effective, but as I mentioned, the cost can escalate if multiple patents are in play. Just quickly touching on timing, what we are seeing is that IPRs are being filed in response to court infringement proceedings at a very early stage. That is, I think, in part a strategy to get in early, but it's also predicated on and subject to the AIA rules. If you are sued or served with an infringement complaint, then the IPR must be filed within 12 months of being served. So there is a time period, a limited time period in which to file your IPR. If PRGs are also available, then clearly you need to wait the 9 months for the PRG to expire before you could then file your IPR. We have seen IPRs being successful even if instituted quite late in the infringement proceedings. So in the Fresnes case, infringement proceedings were not final. Patent was held after IPR to be invalid, and so the infringement action was dismissed. In the E+ case, again, infringement proceedings were held not to be final, and so an injunction and a contempt award was set aside. And in the Versada software case, a slightly different situation. Infringement proceedings were held to be final, despite the fact that the IPR decision was that the patent was invalid, and in that case damages were maintained. So you can get your IPR decision too late, and unfortunately, if that's the case and the infringement proceedings are held to be final, then whatever remedy was made available during those court proceedings will be upheld. Other IPR filing considerations, and this is just kind of a short list of some of the key elements to filing IPRs. The standard to initiate the IPR had it initiated is that there needs to be a reasonable likelihood that the petitioner will prevail with respect to at least one of the claims challenged. The standard of proof is more of a preponderance standard, so it's greater than 50% likely that the patent will be held invalid, rather than, again, the clear and convincing standard. I mentioned the estoppel before, which is certainly an important consideration as to whether or not to institute an IPR. Estoppel will apply to later court proceedings and will bar reliance on prior art that the challenger raised or reasonably could have raised during the IPR process. The other consideration is that the decision makers at the Patent Office, the administrative judges, they are technical decision makers, they're technically qualified, whereas in the court proceeding before a judge or jury, they'll need expert help. And so that's another factor to consider. The decision is very fast to conclusion, 18 to 24 months. And historically, over recent history, the likelihood of being successful in, if not completely knocking out the whole patent, certainly knocking out key claims, has been very high. We have seen that success rate drop over the last few months, however. There's limited discovery, some discovery, but it's very, very limited, certainly compared to federal courts. And the question I also to ask is where is the infringement proceeding taking place? It's likely to be initiated by the PAE in a court that will be more favorable to them. But if you can have that litigation transferred to a court that's more favorable to you on your home court, then perhaps you may want to just take the court litigation through to its conclusion with a feeling that you're likely to be successful based on the art that's available to you for invalidating the patent or other invalidation grounds, and not go through the IPR process with its estoppel and the other reasons. But so there are clearly different considerations. We are seeing in most PA defenses, I demonstrated earlier, that some companies, including in the medical device space, are filing IPRs in direct response to litigation. But that's not necessarily the appropriate avenue, and so we need to weigh up all of the different aspects of and considerations of filing an IPR in addition to defending yourself in the court. So defenses via the USPTOs, we're seeing that most IPR petitions have been against MPEs, 61%, 35% against industry, so those are the patent owner breakdowns. And if we look at pending litigation, where there's related litigation, so there's an IPR in existence and there's related litigation, we're seeing that 403 out of the 483 petitions, so that's 83%, are related to pending patent litigation between the same parties. We're also seeing that where stays have been requested, and there have been 159 stays of the litigation subject to decision of the IPR, that's been granted in 73% of the time, and that's 2014 AIPLA data. In the UPC, EU national courts, clearly counterclaim for invalidity is an option. Revocation actions are also quite prominent. In Europe, there's no standing issue to address. European oppositions, as in the US now with post-grant reviews, there's a 9-month window after grant. Those decisions are really quite slow And there is a wrinkle in the patents that are being litigated nationally prior to a final EPO decision can still be enforced. There is a stay, as I mentioned, option. So most courts will stay pending national court litigation proceedings until the opposition and the appeal becomes final. That hasn't always been the case, as I see in the UK. And the central revocation is clearly very a strong remedy, and it applies to all of those countries that were initially designated in the European application. This was the UK decision that I was referring to earlier. It's the UK Supreme Court decision where I think it's just an interesting one and shows the interplay between the EPO and the UK, where a stay wasn't granted. So there were parallel UK and EPO proceedings. No stay of the UK proceedings was granted pending EPO validity decisions. The UK High Court and the Court of Appeal found that the patent was valid and infringed, and an injunction was granted and damages were awarded. The damages hadn't actually been set at the time that the patent was finally revoked by the EPO Board of Appeal. The Court of Appeal then came back and, in view of that EPO decision, they discharged the injunction, but they maintained the damages. The Supreme Court overturned that damages decision and said that, in effect, the patent really never existed, and so the damages should be set aside. In contrast, the French courts have held slightly differently, and they determined that a final decision on infringement could not be undone by a later invalidation of the subject matter. I guess it depends what you mean by final decision, and whether you'd hold that the UK court decision was not final, but it looks pretty final in that the injunction was granted and damages were awarded. So will the FTC come in and help if you're challenged by a patent assertion entity? Well, perhaps, but not yet. There's one case that the FTC looked at, but that was against a pure patent troll, MPHJ, and they looked at this late last year. MPHJ sent something like 16,000 warning letters to different companies, and the technology was around network computer scanning. It was held by the FTC that this particular troll had falsely claimed that their patents had been licensed to a substantial number of companies for significant sums of money. That's what they asserted in their warning letters, and that was found not to be correct. The FTC therefore charged them with using deceptive sales claims and phony legal threats. So in that case, the FTC clamped down on their particular activity. There's one other case that's kind of wending its way through the courts, Intellectual Ventures versus Capital One. It's in the banking area. The Virginia District Court has dismissed all of the antitrust counterclaims that Capital One raised in response to an infringement suit. They're also having another go in the Maryland District Court, and just recently that court has allowed Capital One to pursue its antitrust counterclaims. So we'll see how that plays out. I think the best hope for FTC activity, if you want to gain any traction in clamping down generally on PAE practices, is the ongoing FTC study. It's called the 6B study. It started towards the end of 2014, and the final report is anticipated by the end of 2015. One of the things that the FTC is looking at is the practice of what they call privateering, which is where an operating company sells or licenses a patent to an assertion entity, which in turn enforces the patent against the operating entity's market rivals. So, that's clearly covering some of the activity of the case here, and Marathon buying patents, portfolios of patents from medical device companies and other companies, and asserting them against their competitors. Finally, and I think this is the last slide, will legislation mitigate the threat? Well, it's possible that we'll see patent reform again in 2015. There are, at least as of today, I believe, only two competing bills, one in the House, one in the Senate. The Innovation Act was submitted in February by Congressman Bob Goodlatte. That's essentially the bill that passed in 2014, but it's been reintroduced in 2015. Just earlier this month, the Strong Patent Act was submitted. It is a counterbalance to the Innovation Act, and is introduced in the Senate by Senators Coons, Durbin, and Hirono. Those two bills cover very different grounds. There's some harmonization between the two in terms of how to treat IPRs and changes to IPRs or IPR practice. But generally, we're at very different ends of the spectrum. So consolidation, review, trying to consolidate those two bills into an act, it's going to be really quite challenging. So that completes the presentation for today. If you have any questions, we'll be happy to take those and respond to them.
Yes, thank you so much, Lee. Wonderful, wonderful presentation there. And thank you to those who have stayed on the line. If you could submit your questions directly to me via email at webinars@q1productions.com. I'm going to be speaking with Lee, and we will find a time to get those questions answered, and we'll send that recording out to all of the attendees as well. If anyone needs a certificate of completion for today's webinar, please send me an email, and I can provide you with that. But I will be in touch just a few minutes with a copy of the presentation recording, slide deck, and feel free to reply back to that email with any questions. And I'll also be sending out a survey later this afternoon just to get everyone's feedback on today's presentation, which I'll of course be sharing with Lee as well. So do be on the lookout for those emails from me. But again, anyone who has any questions, please feel free to submit those via email to webinars@q1productions.com, and Lee and I will work together to get them answered. Again, thank you to all who have stayed on the line, and thank you to everyone for attending and investing your time with us today. We definitely hope you found the course helpful. But a big, big thank you to Mr. Lee Caffin, who is the Senior Consultant at Questel Consulting. Lee, thank you so much for giving a very thorough presentation and providing us with insight. Very, very helpful, and we certainly appreciate your time and consideration. And want to wish everyone a wonderful rest of the day. Thank you so much. Bye-bye.